Your Honours, case number IT 9937 PT and case number IT 0150I, the prosecutor of the tribunal against Slobodan Milosevic.
Here the appearances, please.
If it please the Court, Dirk Reineveld, Senior Trial Attorney for the Kosovo indictment, along with Madam Prosecutor Carla Del Ponte and my colleague Hildegard Ertz-Retzlaff for the Croatia indictment.
Yes, Mr. Kay.
Stephen Kay of Queen's Counsel of the Bar of England and Wales.
Michael Vladimirov, Member of the Bar of the Netherlands.
Branislav Tapušković, Member of the Bar from Belgrade and an attorney from Belgrade, Member of the Bar of Serbia.
The purpose of this hearing is to deal with four matters, which we will deal with in this order. First of all, the hearing of argument on a number of motions. Secondly, the reading of the Kosovo indictment and the accused to enter a plea on one count if necessary. The initial appearance on the Croatia indictment, and finally a status conference. As to time, we have available today, and if necessary tomorrow morning. However, the reading of the indictments is going to take some time. But nonetheless, I hope it may be possible to finish today. We begin with the motions hearing. And the matters to be considered are these. First of all, a prosecution motion for leave to file a second amended indictment, and then various preliminary motions and documents from the accused, together with a brief on jurisdiction from the amici curiae. And we'll deal with these motions in this way, that first we will hear the arguments of the prosecution and the amicus on the motion to amend the indictment. We will next hear the arguments of the amicus and then the prosecution on the preliminary motions. And finally, we will hear the accused on all motions. We begin then with the prosecution motion for leave to file a second amended indictment. This is under Rule 50 of the Rules of Procedure and Evidence, which provides that the prosecutor may amend an indictment after the assignment of a case to a trial chamber with the leave of the chamber after having heard the parties. It may be of assistance if I summarize the issues which are raised under this motion. The motion states that the reasons for the amendment are as follows. First, to reflect the link between killings in Kosovo and the bodies found in mass graves near Belgrade. Second, to add an additional count of forcible transfer. This relates to the Kosovo Albanians who were internally displaced within Kosovo rather than actually deported. Thirdly, to break down the allegation of persecution in count 4. This amendment seeks to particularize the various persecutions and to replace the earlier very general allegation. Fourth, to add a new section on individual criminal responsibility under Article 7.1 of the statute. This is said to be in order to specify what the motion calls common purpose liability. As the Chamber understands it, the amendment seeks to clarify the prosecution case in this respect and spell out that the prosecution rely on a joint criminal enterprise in which each of the accused participated. Fifthly, to add 3 new sites from which the deportations took place and to expand on others, adding more background. And this includes a number of allegations of sexual assault and destruction which were carried out during the deportation operations. There are also various stylistic changes and the rearrangement of some parts of the material. Now, that's intended to be a brief summary of the scope of the amendments, which on the whole speak for themselves. Now, I'm going to turn to the amicus first. Mr. Vladimirov, we got your letter of last Friday stating that you wouldn't file a brief on this motion, but there might be some procedural issues to be raised. Is there anything you want to raise on this?
We have no further observations at this stage, Your Honor, but maybe later on we may come back to the procedural aspects of any amendment if given leave by the court.
I think we could hear you better if you were on your feet.
I apologize.
No, we heard that. So you don't want to make any points about the amendment?
Not at this stage, Your Honor.
But there may be some subsequent issues which arise out of it. Well, we could deal with them in the status conference.
That's right.
When we will be timetabling the indictment.
That's what we had in mind, Your Honor. Thank you very much.
Thank you. Very well. We will hear any submissions from the accused on this issue in due course. We go on to deal next with the preliminary motions. And in this connection, we have the following motions and other documents, all of which we've read. A motion from the accused of the 9th of August, of which she's asked us to consider paragraph 8 only, which we have done. A response from the prosecution, filed on the 16th of August. A presentation, as it was termed, filed by the accused on the 30th of August, relating mainly to the alleged illegality of the tribunal. This we will treat also as a motion. The brief of the amici curiae on jurisdiction, filed on the 19th of October. This adopts and expands the arguments of the accused. And finally, the response from the prosecution of the 26th of October. As to the argument, we'll hear the amici first, then the prosecutor, and finally the accused. Who wants to start for the amici?
Thank you, Your Honor. Each of us will deal with matters as raised in the brief. We have not much to say in addition to what we already wrote in our brief. We have some observations to make, and I will start to do so.
I should say, just to make it clear, that we've had their submissions, for which we're grateful. We've had the chance to read them, so there's no need to repeat either what you said or indeed what the prosecutor has said.
That's exactly what we had in mind, Your Honor. We are not here to repeat things that has already been written or said. The first observation I want to make deals with the position of the amicus curiae and the position of the accused. We pointed out in our brief that the accused should have full opportunity to express himself and to make any statement that is relevant to argue his case. Here, perhaps it would make sense, perhaps I stop here, because while I'm talking, all things happens here and I have no clue what is going on. Perhaps I should move a little bit to the right. There's little room here, Your Honor, but we're trying to do it. First of all, I want to say that the amicus curiae, during the pre-trial position, each of us, we feel that we should not raise issues that have not been raised by the accused. So at this stage, we feel appropriate to react to issues that has been raised by the accused, and that's for the very reason that we do not want to replace him in terms of raising issues. It's for the accused to raise the issue, and we are there to comment on that by assisting the court in supplying legal reasoning for the arguments raised by the accused. So in this approach, we feel that the court should allow the accused the broadest possible room to maneuver to argue his case. And as we have said in our brief, that also may include reasons which on the face of it might not directly be legal reasons, but more or less political reasons. Because the establishment of the tribunal, his main challenge, also includes, as we have set out, possible political reasons.
Mr. Vladimirov, I've heard your explanation as to the understanding of your role. I understand what you have said, but in my view, it is perfectly open to the amici to raise any arguments that they wish, so long as it will assist the chamber. And that is perfectly clear from the motion, from the ruling that the chamber gave. So I understand what you have done, but for the purposes of the rest of the trial, I think it is important that you understand that your role is a bit wider than that. It is not simply to react to arguments raised by the accused. You are there to assist the chamber in the consideration of this case.
We understand that, Your Honor. What I tried to explain is at this stage, during pre-trial, having the first motion, we feel that we should approach the matter in a very delicate and diplomatic way and find our way through this method of being not overreacting to anything that's going on or taking initiative where we have no idea what the consequences are. So we start in a very moderate way and develop from there. That's the reason why we do not feel it appropriate to raise issues at this stage, at the very beginning, that have not been raised by the accused. We may do so later, but not at this stage, because we feel it's for the accused to guide all of us what he is looking for, what kind of arguments he's looking for, to tell the court what he is thinking, what he wants. It's not for us to narrow that possibility, so we are very, very, let's say, moderate at the very beginning, and we will develop from there.
Very well, I understand the conservative approach that you have taken, but please understand that your role is a bit wider than that. So, please proceed.
We may come to that, Your Honor, and I'm confident that at the end of the day, and that's more than today, I hope that the amici curiae will be able to do what we have to do in the interest of the accused and to assist the court in finding the right answers to issues that have been raised in this court. But please allow us to start as delicate as we can. Perhaps I should move on to the next issue I want to touch on. It's a very brief observation as well, because actually we feel everything has been said in our brief, and that's the issue of whether previous decisions of the court or the appeals chambers are binding or not. The amici curiae are perfectly aware of the decision in the Alasovsky case, and we are also perfectly aware of what the appeals chamber has said there. However, we also believe that whereas in the statute there is no guidance on the matter we are now discussing, it is not expressed by the statute nor by the rules how to deal with the matter. It is by itself a matter of case law how to understand the issue. The appeals chamber in the Alasovsky case found that generally in common law jurisdiction there is more binding with previous decisions than in civil law jurisdictions, because there's no doctrine there. And I think there is some logic in that observation, because if law or a system derives from a statutory system where most issues have been described in a statute, there is less reason to rely on previous decisions of courts interpreting those statutes. While in common law, people take more precedence from previous decisions, and therefore the system of previous decisions, the case law, is more important for the functioning of the system itself. Different to the appeals chamber, we feel that in the system of the tribunal, there is a statute, there are rules. One may argue that those rules may not be complete in terms of dealing with all possible issues, but as a matter of fact, they are dealing with all possible issues on a basis that may be different to what one would see in a statute on, for example, the European continent, but still there are rules. The answers are in the rules and in the statute. From that point of view, we argue that there is no need to rely on previous decisions in the meaning of they are absolute, they are absolutely binding. We feel that previous decisions have the importance of being authoritative, and they should be of guidance for the judges, and they should follow them unless they may depart from them, so to say, unless there are cogent reasons in the interest of justice not to do so. So it's not an absolute thing, it is a relative thing. Now, as we have said in our brief, we believe that on the merits of the case at hand, the trial chamber is free to depart from previous decisions and to see whether there are any specific circumstances or argument raised by the accused or enlightened by the amicus curiae, and therefore the Tadić appeals decision is of very authoritative importance of this trial chamber, but on the basis of guidance. Now, if you carefully study what we have said, and you have done so, you will realize that we are not actually challenging the Tadić decision. We are following it, and we argue that on basis of that decision, and we will come to that later, we advise the trial chamber to ask for an advisory opinion of the ICJ. We are not saying that the trial chamber should rule differently to the Tadić appeals decision. And actually, in the Tadić appeals decision, the issue had not been raised, so it's a novelty. Let me see if there's any other reason to make more observations about this one. The next issue will be discussed by Mr. Kay, and that is the issue of independence of the OTP or perhaps the tribunal. So I will give him the floor, if you agree with that.
Just a moment. Could the registrar come, please? Yes, Mr. Kay.
Thank you, Your Honour. I'm dealing with two matters in relation to the brief of the Amici Curiae filed on the 19th of October. The first of those matters is set out at paragraph 10 of our brief and takes in paragraph 11. And then I'll go on to deal with paragraphs 12 and 13, which is the right of this tribunal to try a head of state, and so is therefore an argument raised by the accused concerning the right of state sovereignty. Dealing with the first matter, it's quite clear from the points raised by the accused in his correspondence and various documents that he has asserted that this tribunal is incapable of giving a fair trial because of its failure in relation to impartiality. One of the key fundamental principles for any valid court of law is the principle of impartiality. Without that, there can be no rule of law and no right to a fair trial. I appreciate this point has been taken several times before in the history of the tribunal, but that doesn't preclude him in being able to raise the matter. In many respects, this argument of impartiality can be linked up with the issue at the end of the brief filed by the Amici Curiae, which really concerns the right of these judges, so to speak, to judge themselves in relation to their validity. And Mr. Vladimirov will be addressing you at the end of our submissions on that last feature of the brief of the Amici, which starts at paragraph 19 and relates to the test of independence and the proposition that for this court to be validated, it should be validated by a principal organ of the UN, being the International Court of Justice. I won't deal with that argument now, as he will, but the point I make is that this issue of impartiality is very much bound up within the validation of the tribunal. The accused has stated within the various documents that the pressure on this tribunal from external sources to try him and others makes the whole culture of the tribunal unfair and biased against him. And that's notwithstanding any issue that there may be concerning the right to try him in the first place. The indictment that was issued against him in 1999, at the time of conflict, was as the result of the Security Council urging the prosecutor to take action in relation to events in Kosovo. Before that time, it appears from the court records, there was no public or secret indictment against him. It wasn't until those political events in 1999 that the first indictment was issued as against him.
The document on which you rely, I think, was from the Security Council in March 1998, according to my note.
The 31st of March 1998.
The indictment didn't come to a year later.
Yes.
A year later.
Obviously, there's preparation of these matters, and when that indictment came out, the accused at that time was in the middle of a situation of international conflict.
It was merely urging the prosecutor to investigate violations of international humanitarian law. Are you saying that the Security Council shouldn't have done that?
It's a pressure upon the prosecutor, whose job is derived from the Security Council in the first place, that it would be difficult to say that party could thereafter act independently. And that's the point that's being made here in the submissions of the accused.
Mr. Kay, in order to substantiate that, wouldn't you have to go a little further and show that pressure was applied to the prosecutor in her decision to indict Mr. Milosevic? Is there any evidence of that?
With respect, I think it's for the prosecutor to prove there wasn't. It's impossible for an accused or a party in any other position to prove a negative. We're simply not in possession of any of the facts or information.
But you are making the allegation of a breach of independence. In my view, the onus is on you. You are alleging the lack of impartiality on the part of the prosecutor. The onus is on you to show that lack of impartiality.
What's being asserted here is that there is a suspicion, a reasonable supposition that could have been the position. As far as the accused is saying within his documents, it would be the definite nature of the allegation. If an assertion such as that is being made in relation to jurisdiction, surely it's for the party who is seeking to establish the jurisdiction to prove to the contrary. For an accused or any other person to be able to take such an argument on the basis of evidence that is not in his possession and would probably never be in his possession, in terms of documents or material evidence, it really amounts to an impossibility.
You've got to make some sort of showing that there is an absence of impartiality or independence as a result of an urging by the Security Council not to prosecute this case, but to investigate, as I say, violations of international humanitarian law. It may be you can't take the matter any further.
No, perhaps this is the sort of issue that when an indictment is confirmed, in view of the general circumstances in which the indictment arose, that the prosecution should seek to justify the position of the issuance of the indictment in the first place. And it may well be that in the early procedural stages, that is when such a course should have been taken on inquiry by the court itself, the confirming judge, Judge Hunt, in relation to the reasons for the issue of the indictment. We have cited an example within our brief that arose in relation to the manner of detention of the accused, which can be looked at as being an example, if you like, of the kind of impartiality that he asserts. He has been forbidden from speaking to the media or the press, whereas other organs of the tribunal are in a position to be able to do so. From his perspective, that can be seen as an impartial regulation of the respective positions of the parties. But this issue of impartiality is fundamental to his right to a fair trial, and in many respects that's why we say the proposition at the end of our brief is the proposition that is the true test of validity. Shall I turn now to the second argument that I'm dealing with, unless your honours have any further issues outside of that which we've written in our text concerning the issue of impartiality?
No, if you'd like to go on.
Thank you. This relates to the jurisdiction of the tribunal against him as an individual, as the former president of the Federal Republic of Yugoslavia. The court knows, and the prosecution has cited, as indeed we cited, the Article 7, Sub-Article 2 of the statute that states those acting in their official capacity as head of state may be subject to the jurisdiction or be held criminally responsible for acts before this tribunal. However, this is an issue here that is probably the oldest and most fundamental rule of the governance between states, and that is the principle of state sovereignty. History is full of examples of attempts to prosecute former heads of state, as we have cited in our brief, none of which were put into effect, and the position of President Milošević here, one can say properly, is now unique, if not historic. The prosecution in their response have cited the case of the Prime Minister Kambanda in relation to the Rwanda tribunal, but that was a plea of guilty, and that was not an issue that had to be decided by the court itself upon this issue of state sovereignty. As I said, the oldest and most fundamental principle that has by international customary law governed the relationships between states, which has in fact been inviolable, has been the issue that a state retains its sovereignty and its leader cannot be put on trial for acts committed in that official capacity of acting on behalf of the state.
Mr. Kay, you must be aware of the vast number of instruments which contain a provision similar to Article 7.2. And I believe you should be aware that by this time, the provision in Article 7.2 reflects a rule of customary international law. With the development of the doctrine of individual criminal responsibility, which commenced after the Second World War, a number of instruments incorporated and reflected that principle. Article 7 of the Nuremberg Charter, Article 6 of the Tokyo Tribunal Charter, Article 4 of the Convention for the Prevention and Punishment of the Crime of Genocide, and most recently, Article 27 of the Rome Statute for an International Criminal Court. At this time, I'm at a loss as to how you could argue that the principle in Article 7.2 is anything but a rule of customary international law in relation to the kind of crimes with which the accused is charged.
Article 7.2, of course, arrives from a statute that arose from the Security Council. And as one looks at the materials and documents filed by the accused, his principal argument is that this was not a tribunal that was set up by the General Assembly of the United Nations, but by the Security Council.
Well, that has nothing to do with the question whether what is in Article 7.2 reflects the rule of customary international law. The fact that it came from the Security Council doesn't go to that question. What determines whether it is a rule of customary international law? Primarily two things. State practice, how widespread the state practice is, and principally the feeling among states that there is a legal obligation to abide by that rule, the opinio juris, and all the instruments that I have cited, including most recently the Rome Statute, clearly reflect this. So I can't understand the argument coming at this stage. Perhaps immediately after the Second World War, but not some 50 years after that.
Of course, no previous heads of state have been subject to a trial, and that is a point in itself probably worth making on this issue. The international customary law in relation to state sovereignty still retains itself as a principle, I take Your Honour's point that in relation to these particular violations, that there have been a number of moves within the international community for the trial of violations of humanitarian law, and that has to be recognised.
Okay, let us take the recent case from your own jurisdiction, the Pinochet case, where the House of Lords held that Senator Pinochet was not entitled to immunity in respect of acts of torture and conspiracy to commit torture, alleged to have been committed in his capacity as the head of state. And I would draw your attention particularly to what Lord Millet said, that in future those who commit atrocities against civilian populations must expect to be called to account if fundamental human rights are to be properly protected. In this context, the exalted rank of the accused can afford no defense. Another example of the state practice contributing to the customary character of the rule reflected in Article 7 of the Tribunal Statute.
Yes, and the interesting thing was, of course, Senator Pinochet was returned to his own country and wasn't in fact extradited to Spain in the event, and we in our brief cite the examples of Pinochet and Noriega.
He was extradited or returned on grounds which have nothing to do with the validity of the principle that we are examining now.
Yes. And a national decision, it doesn't bind an international court.
It doesn't bind, but it goes to the question of the development of custom, of a customary rule of law. And it is quite clear that decisions of national courts can be considered in determining whether a rule of customary law has developed. That's very evident, and no citation is needed for that.
And far be it from me in any way to diminish the standing of my own House of Lords, but as far as that decision was concerned, which also involved at one stage an issue of impartiality, which I've held myself back from mentioning earlier on, that decision by that national jurisdiction, which they said reflected international customary law, we say at the end of this brief is an issue that another organ should in fact decide for this court, an organ of long-standing international stature, which is a United Nations organ with great experience in dealing with international affairs and the affairs of the United Nations, which is the International Court of Justice. The self-validation process that has been evident within this tribunal has led to the apparent feeling of impartiality by those over whose affairs it seeks to regulate. And I just say that because of the time-honoured maxim, justice must not only be seen to be done, it must be done as well. And
a colleague is going to argue that point. So
yes.
Don't preempt him.
No, far be it from me either. But the point here, that this issue of state sovereignty that the accused has raised on his own behalf is a valid and historic argument that, if one looks at the history rather than the political intent, has shown to be a rule that has been applied in many circumstances. And that is what he is pleading on his behalf as a valid reflection of international law.
Well, Mr. Kerr, I think you've covered the points, unless there's anything else you want to raise.
grateful, Your Honour.